The Supreme Court recently held a lengthy hearing on immunity for crimes committed during a president's term of office. The almost 3-hour hearing delved into a hypothetical instance where a president with absolute immunity might order the assassination of a political rival. Let's stop right there. Biden's Department of Justice ordered the Mar-A-Lago raid to do a political assassination of President Trump. It's clearly election interference and an attack on our pretended democracy. Let's set aside Trump for the moment. The issue is a 100% corrupt government, plain and simple. Why hasn't Biden been indicted for election interference? Or for bribing Ukraine to stop the investigation of his son Hunter? Or for stealing money from taxpayers to pay student loans? Or for financing proxy wars in Ukraine and Israel? Or for renewing the warrantless spying on Americans under the FISA Act? Or for illegally transporting aliens across the border? It's a crime if you do it, but not if Biden does it. A particularly egregious felony is when Biden and his handlers provided the Taliban with billions of dollars in military armaments with his hasty withdrawal from Afghanistan. Under United States Code, Section 2339A and B, whoever knowingly provides material support or resources to a foreign terrorist organization, or attempts or conspires to do so, shall be fined under this title or imprisoned not more than 20 years, or both, and if the death of any person results, shall be imprisoned for any term of years or for life. All the rapscallions in Congress, in federal law enforcement, and in courts commit crimes daily. The Supreme Court justices and federal judges have absolute immunity for their crimes, and for others, there exists prosecutorial immunity, legislative immunity, and witness immunity from crimes they commit. Yet, the so-called justices plan to rule that President Trump does not have immunity. The fact is that about 95% of what the federal government does is without constitutional authority, and the courts are complicit in upholding them. They are partners in a criminal racketeering organization. Under the RICO conspiracy statutes, each party is responsible for the actions of another even if they are unaware of another member's specific crimes. See Title 18, United States Code, Sections 1961 to 1968. Furthermore, there is no exemption for federal officials operating under color of law. Title 18, United States Code, Sections 241 and 242 are federal civil rights statutes that make it illegal to conspire against or deprive someone of their rights. Yet the government does this every single day. Section 241 makes it illegal for 2 or more people to conspire to injure, oppress, threaten, or intimidate someone in the exercise of their rights or privileges. This includes preventing or hindering someone from exercising their rights, or intimidating someone because they exercise their rights. Section 242 makes it illegal for someone acting under color of law to deprive someone of their rights, privileges, or immunity. This includes acts done under the color of any law, statute, ordinance, regulation, or custom. The ATF, for example, is an agency specifically designed to infringe on the right to keep and bear arms. The federal government has no authority whatsoever to ban any firearm or prohibit a felon from owning one. Yet, the federal government throws people in prison and commits murder to enforce these laws. To wit, Ruby Ridge, the Waco Massacre, and hundreds more less publicized murders. Consider this. It took a constitutional amendment to ban alcohol. Where is the constitutional amendment to ban the possession of certain firearms, silencers, bump stocks, wrist braces, auto sears, or any other firearm components or accessories? And as detrimental as they are, where is the constitutional amendment to criminalize the possession of drugs? James Madison, the principal author of the Constitution, wrote in the Federalist No. 45 that the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects, as war, peace, negotiation, and foreign commerce. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives and liberties and properties of the people and the internal order, improvement and prosperity of the state. Thus, the Constitution does not give the federal government authority over any matters not delegated and enumerated in the Constitution. These usurpations of power are prohibited under the 10th Amendment. But the unconstitutionality of federal laws doesn't stop government criminals from enforcing them. When you go to federal court on any charge, you will quickly find out that the Bill of Rights is meaningless. For starters, the grand jury offers no protection whatsoever because the courts have ruled that prosecutors can use bribery, hearsay, and illegally seized evidence to get an indictment. Further, they can withhold favorable evidence from the grand jury, and you are not allowed to be present. And once you are arrested, your right to bail can be denied on the pretense that you are a threat to society or a flea risk. Ask the January 6th defendants who were denied bail for months while awaiting trial. Then, when you finally go to trial, neither the 1st, 2nd, 4th, 5th, 6th, 8th, 9th, or 10th Amendment will protect you. They are either ignored or watered down. I know because every single one was violated in persecuting me. I explained the tyrannical system we live under in the foreword to my book. They left no crime uncommitted. The fundamental problem with the state, what we more commonly refer to as the government, federal or state, is that it has no morality or conscience. It cannot suffer punishment or be imprisoned for the thousands of legalized crimes committed daily under its name. What's worse, government officials are exempt from imprisonment for enacting and enforcing the legalized crimes they inflict on the public. These officials have also exempted themselves from maladministration lawsuits. For example, no one in government can be sued for enacting laws which violate the Constitution, for the blatant theft of the fraudulent Social Security Trust Fund, for government waste, for treaties that ship American jobs overseas, for inadequately guarding the borders against illegal immigrants and terrorists, or even for bankrupting the country with giveaways and endless wars. The much ballyhooed checks and balances placed in the Constitution by the founders were drafted in their self-interest to preserve and enrich their own status. The historical records show that many of them were rich landowners and merchants who gained high positions of power in the new government which they now controlled. These checks and balances were viewed with well-deserved skepticism by the states when they were being urged to ratify the Constitution. That's why the states demanded inclusion of a Bill of Rights, which are actually a Bill of Prohibitions. These amendments have since been shown to be inadequate. From the very beginning, judicial decisions with their strained interpretations have steadily eroded the Bill of Rights to the point of relegating them to a mere historical artifact. The skeletal remnants have been stripped of any real meaning, though they remain useful to politicians who occasionally pay them lip service in support of their campaigns for public office. Both the Bill of Rights and the promises of a limited federal government have fallen by the wayside as legislators continue to enact a plethora of unconstitutional laws. Today, every American fears the government, or would if they recognized the Damocles sword hanging over each of our necks. The government's ability to arrest anyone at any time is an essential means for holding on to absolute, ruthless power, since it tends to dampen the complaints. In the Soviet Union, for instance, the KGB simply picked up anyone they didn't like right off the streets for disposal. After pressuring you to denounce your family and friends, they would then decide what crime to charge you with, like here. There is no defense in a police state, of course, since everybody is guilty of something, whether they did anything or not. But if you don't confess to something, then your family will be arrested along with you. Like here. You may think you have nothing to worry about because you are not a criminal. That's where you're wrong. According to attorney Harvey Silverglate, the average person commits 3 felonies a day without even knowing it. Fact is that if La Cosa Nostra had courts, they would be indistinguishable from those of the lawless federal mafia. My apologies to the mafia. They don't destroy lives for the fun of it, like the federal criminals do. In conclusion, Trump's immunity defense is this: if the president doesn't have immunity, then neither do any of the federal officials for the uncountable crimes they commit. It's a cruel joke that the words equal justice under law are carved above the entrance to the Supreme Court building. But now the Supreme Court justices must craft a ruling on Trump's lack of immunity while maintaining their own immunity from crimes they commit on a daily basis. They hope a plethora of word, parsing, and precedent scraping will still fool the enslaved masses.